Welcome back to Hardball. We reported on the attorney generals of 14 states who filed lawsuits challenging the constitutionality of the new Obama health care bill. Now, one state attorney general is defying his governor and says he won't join those 14 attorney generals. Here's what happened. Right after health care reform passed, Republican governor, Georgia Governor Sonny Perdue wrote to his attorney general requesting that he file suit on behalf of Georgia. 2 days later, Attorney General Thurber Baker of Georgia wrote back to the governor and said he, quote, respectfully declined the governor's request on both legal and fiscal grounds. He didn't want to waste the taxpayers' money, he said. Now Republicans, some of them in the Georgia state legislature down there, are calling for the attorney general to be impeached. Well, Georgia Attorney General Thurber Baker joins us now from Atlanta. General, thank you so much for joining us. Is it impeachable? I was looking at the law down there. Whereas by failing and refusing to perform his constitutional and statutory duties, are your critics down there saying that you failed to perform your constitutional duties by not saying the president is unconstitutional? Is that their argument?
Chris, that seems to be the argument, but you know there's nothing in the Georgia Constitution and nothing in our statutory laws that requires the Attorney General of this state to file a frivolous lawsuit. The governor asked me to consider filing a lawsuit against the federal government to overturn the recently passed Health Care Act. I took a hard look at the Constitution. I looked at every piece of law I could find on the matter. I came away with a clear understanding that there was simply no basis at all upon which to file a lawsuit, and if we were to proceed in that direction, we simply be wasting taxpayers' money in doing so.
Well, let's cause some trouble. That's what I do here. You know, back in '64 when we passed the Civil Rights Bill in this country, especially that key feature, the Public Accommodations Act, which said you basically, if you open up a drug store, I don't care if you sell tomatoes you grew out back, if you open up that store for business, you got to serve people regardless of race, color, or creed. That's the law of the land, using interstate commerce clause of the Constitution to justify it. It seems to me if you can require a guy who opens up a store, he has to sell to somebody, you can use the interstate commerce clause, say somebody's got to buy some insurance if they're going to be in this country and expect to get treated in a hospital for free. They better darn well pay their fare. Now, why does the governor of your state think that the Civil Rights Bill was constitutional using interstate commerce? Or would he have said that? Or would he be doing the same thing back then if he were governor? Calling it unconstitutional to demand the stores are open to everybody. I'm asking you a tough question. Is he playing the same game those people played back then?
I can't attribute any motives to this governor, but let me say this. Since 1937, this country has been very clear through our U.S. Supreme Court that Congress has a very, very expansive Commerce Clause power, and they can regulate both interstate and intrastate. There is no question, as I've looked at that whole issue, that Congress has the authority to pass the statute that they did. Now, there's a lot of policy disagreements out there. There are a lot of budgetary disagreements out there about the new act. But in my opinion, there's absolutely no basis upon which to say Congress doesn't have the power to do exactly what it's done in this case.
Well, do you think they're making the argument, the same argument that was made against the Civil Rights Bill, especially public accommodations? Is it the same argument the governor's making?
Well, you know, the governor has not couched it in those terms. You know, the governor simply asked me to go ahead and file a lawsuit in this case. As I said, we've looked at a lot of different angles. As a matter of fact, there was an interesting matter, you know, several years ago when then Governor Mitt Romney was the governor of Massachusetts. He actually passed the same kind of statutory provision that required residents in that state to have health insurance. Just this month, a court has ruled in that state, an appellate court, that act was totally constitutional and dismissed the claim. It's the same thing we've got going here now with the federal act.
And I think even Judge Scalia, who's a real strict constructionist, whatever you want to call him, what they call it, original intent kind of guy, he basically believes if you pass a law, it's got to be given real credibility. What do you make of Bill McCollum, your colleague down here in the adjoining state of Florida, who's out saying that this bill is, quote, an invasion of the sovereignty of the state of Florida? He uses the language of Lincoln in the Civil War. This is an invasion of the sovereignty of the state of Florida, and you say it's constitutional. Talk about different strokes.
Completely different strokes, and I just respectfully disagree with my colleague in the state of Florida. Listen, we're all looking at the same set of laws. We understand that Commerce has an expansive Commerce Clause power. We understand that the Medicaid program that we're all engaged in at the state level, that it's a voluntary program. Right here in Georgia, almost 60% of the monies that we get comes from the federal government. States can choose to opt in or to opt out. So we understand that, and there is something we call the supremacy clause. Federal law does supersede state law. So I can't speak for my colleague Bill McCollum, but I can tell you from my perspective, I've been the Attorney General here in this state for 13 great years. I can find no legal basis upon which to engage such litigation. And in my opinion, if we go down that road, we're going to waste hard-earned taxpayer dollars.
General, you're running for the governorship down there against Roy Barnes, another Democrat in the primary. You're 20 points behind. Is this going to be an issue in the campaign, the fact that you won't sue the federal government? Is Barnes saying he will? Is this going to be a Democrat issue as well as a Republican issue?
I have no idea what former Governor Barnes would raise as an issue in this campaign, but I am clear on this point. What we've said in this case is absolutely correct. And you know, this effort to impeach me here in this state because I've told this state what the law is and really told the truth is something that we'll talk about. I'm sure others will talk about as well. But we've done it for all of the right reasons. We've given our best legal advice. That's what the people of Georgia elected me to do. That's what I'm going to continue to do. And I cannot be intimidated by threats of impeachment here in Georgia.
So you're not afraid of the governor? You're not afraid of Governor Perdue? You're not afraid of Governor Perdue?
You listen, we're going to do the jobs that we've been asked to do. This is not a matter of being afraid of one person or the other. What I've been required to do as the Attorney General is to talk about the law, to give my best legal opinion. That's what we've done here, and that's what we're going to continue to do. I will not relent from my position.
Good for you. You know, if you had said you were afraid, that would have been a hell of a news story. Thank you very much, Attorney General Thurgood Baker.